Senate and House Judiciary Conference Committees will, it's one committee, come to order. Want to thank everyone for joining us. And yesterday we did hear the conference committee index in which bills are in conference. We did answer any kind of general questions that we had. The reviser answered those for us, so we can revisit with the reviser as we need to as we move forward. And we were then talking about Senate substitute for House Bill 2144. And I don't recall where we left it. I think you were looking at some proposed offer.
Yes, thank you, Madam Chair. We are still looking at 2144. Again, the House hadn't heard it, and so we were trying to really go through it and figure out what it says. We do have some thoughts on proposed amendments, but we have not really settled yet exactly where we want to go, but we're working diligently on it.
Okay, and the Senate assumes that those diligent efforts will continue and you'll have an offer to make from the House shortly.
Absolutely.
Thank you. Appreciate that. We started, I think, discussion on Senate Bill 500 as well yesterday. 500 regarding failure to comply with traffic citations and getting restricted driving privileges back. And I think we're asking for clarification on what some of the House amendments were, and we heard that yesterday as well. And so are there any other questions for the reviser about what the House changes were to Senate Bill 500? Or are we all clear on that? I think we're all clear on that then. So let me make a quick conference with our side. Just a moment.
We have been working with the reviser. The House committee, thank you, Madam Chair. The House had made a number of amendments, and we've been working with the stakeholders to restore some of those amendments with a little different language. And I think one of the amendments that you made was removing a piece. We're probably going to be okay with that, but we'll wait until the balloon comes, and it'll be restoring certain pieces that you took out. Apologize, the balloon is not ready.
Well, the revisers are going to be busy, so when we're not sitting here, because they have a couple of balloon amendments to be getting prepared. And then one that we sort of talked about a little bit yesterday would be Senate Bill 458, and that's civil asset seizure and forfeiture. And that's on page 2 of the chart. And my understanding is that as Senate Bill 458 is in conference committee, it is the House version of civil asset seizure and forfeiture with the Senate differences removed. Do I have that correct? I think I do. Okay, both revisers are nodding yes. So correct on that. So just to remind the audience and those following along, the difference were um, providing that if you are a person that has had your assets seized and involved in forfeiture proceedings, you would have the ability to request a jury trial at the trial regarding the seizure and forfeiture, and then also would require the Kansas Bureau of Investigation to submit forfeiture fund financial reports to the legislature. So, more reporting there. And the Senate position also prohibited federal adoptions. That meaning, I'm just going to give a high level meaning definition of that, that if a state or local agency did the seizure, then the forfeiture proceeding could be sent to federal level for forfeiture proceedings. If I have that kind of overall broadly stated correctly, I'm looking to the revisers and they're nodding their heads yes. So it doesn't make much sense to, at this point, make the Senate offer be to put all those three back in, because we've already gone down that road a little bit, and the House hasn't put any of those in their House position. So rather than do that, I think it makes sense to start with those three differences. The start could be that it's the Senate position that requiring financial reports to the legislature just to make sure that we have information about what is going on. We heard some factual testimony in committee that 82% of the seizures happen during a traffic stop, and it would be important, however they occur, and in whatever amount, that the legislature, since this is civil assets are seized and forfeited pursuant to an act enacted by the legislature, we ought to hear the report of what's happening out there. How is the law being used and in place? So the the first offer would be that we keep the reporting requirement as the Senate position had it.
Okay, thank you, Chair. So just to confirm, you're thinking we're going to go through each one separately. And the first one that you're going to offer is to put back in the reporting requirement.
Yes, and if there needs to be some tweaks, let's hear what those are and see if we can find some agreement. And there's no kind of set path forward. If we want to make a bundle offer of the rest, that's what we'll do. But at this point, that's the offer.
Okay. Okay. So let us talk for just a minute. Thank you. Okay, thank you for your patience. So as we have talked about it as this side of the table, we are thinking that this really just adds a layer of bureaucracy that is probably not necessary. And so we're not willing to accept your offer, but my vice chair and my ranking also would like to express what they're thinking.
So thank you, Madam Chair. I've spoken with some of the county prosecutors in rural areas of the state, which is where I come from, and they are concerned about the extra burden that this would impose on them. So that's one reason we're not inclined to agree to that.
And then Representative Osmond, if you wanted to.
Thank you, Madam Chair, and thank you, Madam Chair. One of the reasons that we removed this is because the KBI has already, from 2019 through 2022, and we're waiting on the 2023 report, they have this online. We didn't really see a need for the report to actually be presented to the legislature when it is publishable by and accessible to the entire public. So the only thing that I would do is draft a report and additional paperwork to the legislature when we're already gathering that information as it is.
Thank you for the comments. Could I get clarification from the revisor? Is that database that I don't recall what the database is called right now, but the counties are required to report the seizures currently, I understand. Yet sometimes counties fail to report, and I think testimony in committee was, well, there's no kind of consequence for failure to report. Do I have that correct in current law?
Madam Chair, current law in KSA 60-4127, which is section 11 of the bill as introduced that's struck in the new version. Since 2019, the KBI has been required to have this Kansas Asset Seizure and Forfeiture Repository. It has information submitted by every agency that conducts civil asset forfeitures in the state. They're required to submit those reports and then on or before February 1st annually. Each law enforcement agency compiles and submits a forfeiture fund report to the repository. If they fail to do so, they're reported to the legislature as failing to report. That's essentially the main consequence. And the KBI also files a report about the statewide data as well.
And that report is due February 1st of each year?
Madam Chair, the statute requires on or before February 1st of 2020 and annually on or before February 1st thereafter. That's when the law enforcement agency reports are due. And then on or before March 1st, the KBI determines whether they're in compliance. And on or before April 15th, the KBI reports to the legislature any law enforcement agency that is not in compliance. That's the timeline in the statute.
So can we determine, so we've had the February 1st, 2024 deadline that we just heard about, and we've had the March 1st, 2024 deadline. Both have come and gone. Do we have those reports?
Madam Chair, we don't know. We'd have to look in the journal or see if it was received. Usually they're on file with the clerk or something like that, but I'm not
I think
aware.
Representative Osman just said that we don't have the 2023 reports. So we don't yet even have the 2023 report that was required February 1st and March 1st of 2023. I think there's our answer. The legislature is not getting compliance from these agencies that are doing the seizing about what they're doing, what they're taking. We don't have any information after 2022, and they certainly then, it sounds like, have not complied with the 2023 reporting requirement or the 2024. That, to me, and the Senate seems that we need to provide some accountability and some oversight. It's always checks and balances, regardless of what entity we're looking at. And we, the legislature, have the obligation and the duty to hold government accountable. And this is an easy tool to do that. And we're not getting compliance. So it's the Senate position, a strong position, that we have the reporting requirement. So we're standing firm with that.
So if I'm reading this correctly, the only thing you added was that a report has to be made to the President of the Senate, the Speaker of the House. Is that to current law? And
You're looking at section 11.
looking at the very tail end of the bill I'm looking at.
Give me a page number.
26.
You're looking at a balloon amendment. Was that in House committee or? Actually, the report requirement is in page. We'll ask the revisor. I don't want to misspeak. There is in section 11 of the bill, and also in section 10.
Madam Chair, the reporting requirement, and I apologize, I was looking at the original bill where it's not stricken. It was on page 26. It's on page 26 onto page 27 of the current version of the bill. So the Senate proposal was the report from the KBI to the legislature would be due not just to the legislature, but specifically to the president, the speaker, the standing committee on judiciary in both houses, both the House and Senate. And then on the next page, you would not just receive the report about which law enforcement agencies are not complying with the reporting requirements. You'd also receive each agency's forfeiture fund financial report that was submitted under the requirements that they're already required to submit. And if I could, for 1 second, just clarify the kind of two different reports, because I'm getting a lot of external feedback about this while we're sitting here. There are two reports. There's the report that the KBI posts about what's in the database, which is the one that I believe the representative is referring to. And then there's the report that's submitted to the legislature by this statute, which is due by April 15th of each year. And all that report does currently to the legislature is say which law enforcement agencies failed to comply with the financial reporting requirements. That's all the report says.
It doesn't say how much was taken from how many people or.
No, that is done by the database and possibly that larger report that the representative was referencing. But the report to the legislature is just about which law enforcement agencies have failed to come into compliance with the reporting requirements. That's all that's reported to you under current law. And we were able to find the 2023 report that was submitted by April 15th by the KBI, and it's not yet April 15th. So the one from last year is not
due yet.
So I wanted to give the KBI credit. They're not late yet for this year.
Sure, of course. So what about the 2022 report? Is there a 23 report missing somewhere else, or that's the one you're talking about that was made, but it's not online?
Madam Chair, the 2023 statutory report about which law enforcement agencies did not comply was filed, and research was able to locate that. I believe the 2023 report that the representative was referring to is not available yet, is a larger report about the data that's in the database. And I don't believe there's a statutory requirement that the KBI make a report necessarily. The requirement is that they maintain the database. And so that might be the distinction here.
So it wouldn't be the reporting wouldn't be from the county prosecutors. It would be from the KBI when they submit their information to the fund. So let's, I'm sorry, go ahead. Representative Lewis.
Thank you, Chairwoman. What I was referring to is it says on or after July 1st, 2019, each seizing agency shall report information from taking seizing agencies to include locals shall report information concerning each seizure for forfeiture to the Kansas Asset Seizure and Forfeiture Repository as required by this section and the rules and regulations promulgated pursuant to this section. The prosecuting attorney, I'm reading that as county attorneys, for instance, district attorneys, shall submit information concerning each forfeiture action to the seizing agency within 30 days after the final disposition of the forfeiture. So that's maybe I'm misunderstanding that, but I read those to be dictates given to the local agencies and prosecuting authorities.
Well, wouldn't it be true that if the local taking agencies and the local prosecutors find it too much of a burden, then they just wouldn't do the seizing? I mean, you only have to report if you actually do seizing.
That's true.
So if they found it too burdensome, they wouldn't have to engage in the seizing.
Not necessarily.
Oh, they would seize but not report? That happens sometimes?
I don't know. That was what I was told by several, that this became quite burdensome at some level.
Too much of a burden to report to the legislature what they've seized?
That's right.
I'm not sure that, when we're weighing due process rights and, the government has seized your property, that, I would think we would want some checks and balances provided and some oversight.
I mean, I'm talking about counties in the southwestern part of the state where there is one attorney in the county. I'm talking about in the county, not the county attorney's office. And those kind of situations do become quite burdensome when you add layer upon layer of reporting requirements and this and that.
Well, what about the burden to the Kansan who has had their assets seized and not charged with a crime or convicted of a crime, and that they then are burdened with having to prove the innocence of their property without, in the House position anyway, the opportunity for a jury trial? And so, whose burden are we worried about here?
I think we're worried about everybody's burden. I mean, it's a balancing act.
Well, I would think as the legislature, we're looking out for, we're the voice of the people, and for the Constitution as well.
So if I may, Madam Chair, and just this would be a question for the reviser. The House position didn't speak to the reporting requirement. I mean, the Senate's version, I'm just going to call it the Senate's version and the House's version, if that's okay, because we know what we're talking about. The House's version did not speak to the reporting. The Senate's version did. So when we took the language out of the bill to make it the House's version. And so, if I'm not mistaken, all those reporting requirements of the counties to the repository with the KBI, that even in the House's version, that is still law. That's still in statute. The change that I believe the Senate made is that the KBI shall report to, rather than to the legislature, they're reporting to the President of the Senate, Speaker of the House, standing committees of Judiciary in the Senate and the House. And then they're also reporting any law enforcement agencies in the state that fail to come into compliance. That's already, but what changed was they also have to report each agency's forfeiture fund financial report submitted pursuant to Section D. So we're not changing the fact that they're still reporting. It's just two changes: one, who it's reported to, and then adding the forfeiture fund financial report is what was the Senate's version, and we decided to take that out. Is that correct?
Yes, Madam Chair. So that you both had your own separate bills to start with. So the House bill that was originally introduced didn't make any changes to current law related to reporting. So the report that's required by the prosecutor that's a current law report, and neither the Senate version or the House version made a change to that reporting requirement. The Representative Humphreys accurately reflected the change in law in the Senate version to the reporting. Current law requires the KBI to report on the agencies that are not in compliance. This expands to whom that report needs to be given. And then it adds that agency's fund report, which is now just put in the database, would have to be, still put in the database, but also sent directly to the legislature.
So no further burden to our prosecutors.
Madam Chair, the way we read it, it doesn't change anything about the prosecutor's current law reporting requirement. They are required to report to the KBI, who then puts that information in the database. But the change is specifically each agency's forfeiture fund financial report submitted pursuant to subsection D. And that's a reference not to the prosecutor report, just to the law enforcement agency fund reports.
And the change to make it to the legislature. And that would seem to me then to address the concern of what's more of a burden to our local prosecutors. I think that would help address your concern.
Yeah, I stand corrected. I mean, I did get calls about the burden, but I stand corrected in terms of my understanding of what we just talked about, so that this won't add any further burdens.
Well, we thank the reviser for the clarification for that part of the reporting. So that's important to know. Well, let's keep that under advisement. Now that we have a clear picture of what the reporting would do, it would provide some more transparency to the procedure of civil seizure and forfeiture, civil asset seizure and forfeiture. And then the two other pieces that the Senate had a strong position on were, if you're the person who had their assets seized and are now in a forfeiture proceeding, you, if you want to, can request a jury trial. And also that if your asset was seized, then the Senate position also prohibits the federal government from conducting the forfeiture proceedings. It would have to stay in state court rather than federal court. And the House rejected those. So do you want to speak to those, or the why?
Yeah, I'd be happy to speak to those. I would say that specifically with the jury, I think the compromise was the fee shifting. And so that was certainly a compromise. And we are considering the House bill to be the compromise from the Judicial Council and also from the interim committee. And the language that they came out with was the House position. Now, I will grant that the report from the interim committee also said these are things you might want to consider later. The jury trial, the federal adoption, that was for later. We are really in agreement, I believe, that the House position, both sides came quite a ways. And no one is really happy with everything that happened, not law enforcement or, the other side. And would some of us like to see things go further? Yes, I have said over and over since 2017, when I first heard of this issue from Representative Gail Finney, when I was on the Judiciary Committee, I was shocked that this was something that actually happened in Kansas. So I have been a proponent of reform to civil asset forfeiture. And when this tough issue, and we have been fighting, for this for a long time, when this tough issue came and the compromise was made, then it seemed really the middle ground was the House position. So, but speaking specifically to the jury issue, when the fee shifting was compromised, then what needed to stand firm, according to what a true compromise position would be that the jury trial would not be part of that. And the other thing people spoke to, would it clog up the courts? You know, how do you decide? I mean, it's gonna actually really increase the fees, and if the fees shifted, that's a consideration. So that's the jury. And then the federal adoption, I have come to understand it better just in recent weeks, since we've really been talking about it this session, and understanding the importance of being able to transfer the forfeiture to the federal government, because when it's a drug ring, when it's some sort of, interstate issue, and there's an asset that's seized, but knowingly there's something going on with either the state of Missouri or Oklahoma, people are driving through, whatever it is, if it's a car, if it's cash, whatever it happens to be, then being able to transfer it to the federal government as with an investigation. I mean, we're not talking about, they're not just working on asset forfeiture. It is tied to an investigation in pretty much every case, from what I understand anyway. And so it seems like it is an ability of law enforcement to get help in their investigation when they believe that it is necessary. And so, I'll let my vice chair ranking speak to it if they would like to. But as far as those two issues, thinking through, we are willing to, at this point, stand firm with the House position.
Thank you, Madam Chairs. So I can tell you that as a federal prosecutor, former federal prosecutor, that federal adoption especially in large cases, is something that's very important if you're going to work with your state local law enforcement. And I just think if we start to prohibit federal adoptions, we're going to infect that relationship in ways that is not going to be helpful, especially when we're faced with the fentanyl epidemic. It was only last week that a huge amount of fentanyl was seized in Ark City, and reading from the reports, it seems that was a local police investigation, and I would hate to tie their hands if it's necessary that they turn this over to the federal government, which has more resources to prosecute and to bring civil forfeiture assets than the locals do. So I think if we start to wade into the relationship between the state and federal prosecutors and investigators, we're wading into an area that we're really not well suited for. I think it should be left to their discretion.
So it's always the legislature's duty to hold government accountable, even when government acts in what government deems a good cause, such as fighting crime, such as fighting the drug war, such as fighting the fentanyl crisis. It is always the legislature's responsibility to, again, hold government accountable. And sometimes government agencies aren't we see it often that government departments, government agencies don't always act correctly, and it's this body's duty to hold them accountable. And it is this body that created this civil asset seizure and forfeiture in 1994, 30 years ago. And I believe, with the help of law enforcement and prosecutors, and yet over the 30 years, have we seen drugs become a bigger problem in Kansas or a smaller problem? In fact, drugs have become now minute, right? A lethal dose can fit on the tip of a sharpened pencil. Whereas before, when it was, for instance, marijuana, it used to require acres or at least some more work than just being produced in a lab. And we have seen facts and evidence that entities and jurisdictions who engage in civil asset seizure and forfeiture actually have a worse record of preventing crime. So while it may be the belief that this type of process works as intended, the evidence, the studies don't show that. I asked multiple times the opponents of the bill, what study do you have to show that civil asset seizure and forfeiture helps reduce crime? And no one had a study to share. Nobody had a study to share. When there are many studies that show the more seizing and forfeiture you do, the worse crime you have in our area. So I also feel it's our duty and our obligation as a legislature to look at facts. We hear lots of anecdotes, but when we look at facts, the facts just don't support that this kind of process works. And let's remember what the process does. We heard testimony that in particularly the Wichita area, there would be persons who had just cashed their paychecks and they operate in a cash basis. They don't have bank accounts and they would be coming from the bank and with their cashed paycheck and be stopped and have their cash seized, even though they showed the receipt. This is my pay stub. This is the cash amount that matches. And it didn't help in that instance. And we've heard, someone for 20 years had I think their $20,000 seized because they, I think, were going to an auto auction and they weren't successful with the bidding. So they were returning home with the cash and that was seized. And remember, these are folks who there's no requirement that they be convicted of a crime, much less charged even with a crime. So if we're so convinced that this is a product of crime, why aren't they being charged with crimes and it proven to be so? So with the Senate position, it provides the person who has had their assets seized and in a forfeiture proceeding the opportunity, if they would like a jury of their peers to hear, hey, I was just leaving my job and the bank with my cashed paycheck and here it matched and I would like my money back. Why would we as the legislature want to deny someone the opportunity? A jury trial is kind of the foundation of our legal process, our legal system here, and it provides a big checks and balance on what government can do. And with the federal adoption, the Senate position would not prohibit if there's a joint task force, if state, local law enforcement is already involved in a federal task force, that wouldn't be impacted by the Senate position. What it does is, if you're thinking about it, we have testimony from law enforcement that it costs $5,000 to hire an attorney to try to get your $2,000 back. That is the system that we have created. That is the system that we have in Kansas. Some states abolish the civil asset seizure and forfeiture procedure altogether. And so really that's one position, and then having some is another. So there's been no compromise with the Kansas Judicial Council. I think that the Kansas Judicial Council, if you'll recall, Madam Chair, you're part of it as well, that we were very adamant when we heard the report of the advisory committee, which is not made up of people serving on the Kansas Judicial Council. like our committees in the legislature are made up of legislators, but subcommittees in the Kansas Judicial Council aren't made up of Kansas Judicial Council members necessarily. That the council was very clear to make no recommendations. And then we had the interim committee, and the interim committee does not bind the legislature in any regard at all. And there has been no compromise with the Senate, with stakeholders out of those conversations. So I don't mean to be pontificating any longer than I already have, but we do need to recall what we are doing here. We are taking money usually, and it's 82% of the time the result of a traffic stop, the study and the evidence shows, and they're being deprived of their property. And then they're in this convoluted system that our sheriff has written. It costs $5,000 to try to get your $2,000 back. And the studies show also that it's minorities and low income folks who are most adversely impacted by this procedure that our government entities are undertaking. So I agree with the House chair that it is far past time to take a look at some reform. And when you're the person on the receiving end of this, that you're having your assets seized, and we the legislature would be telling them, well, no, we don't think you should have a jury trial if you want one, because it's too much of a burden on government. Well, now wait a minute here. Who are we protecting here, government or the people? And if you think it'll take too long to have a jury trial, you don't have to have a jury trial, because it will only be your decision, the person getting their assets taken. And for federal adoption, let's recall also that if your property gets sent to the federal level, there are only 2 federal courthouses in Kansas. So a bigger burden on those in the most rural areas of our state who would have to travel either to the courthouse in Kansas City or the courthouse in Wichita. So again, who are we placing the burden on? And the person, again, who's had their assets seized hasn't been proven guilty or even charged with a crime. So I apologize for the long pontificating, and thank you for your indulgence. And is there any comment that our colleagues from the Senate want to share?
Thank you, Madam. Do you want? Thank you, Madam Chair. Respectfully, I'm very strongly with the House position on this. I will not agree to any conference committee report that has federal adoption in it or that has jury trials in it. I think for a couple reasons. I've got kind of 3 principal reasons. The first is that one of the things we've done since I've been in the legislature, and I know well before that, is with these delicate, sensitive issues, we continually ask parties to come together and come to us with a compromise. And that is exactly what happened here. We had a lot of different parties, different stakeholders with different interests come to the table and really delicately negotiate a compromise bill. And that's the House bill. And as the House chair shared, not everybody got exactly what they wanted. In fact, nobody got exactly what they wanted. I think that's the mark of a good compromise. And so my view on these things is that when we do ask parties to compromise, they come to us with a reasonable compromise and say, we've reached an agreement. Unless there's a really compelling reason to disturb that agreement, I think for the most part that the legislature should honor that agreement. Or else I think we risk breaching the trust of these parties in the future when we say, hey, go work something out. Then they spend all this time and energy in working something out. And then they come back to us and we say, well, we don't really like exactly what you worked out. We want to change what you worked out. So I've not yet been presented with any compelling reason why we shouldn't honor the very hard worked out compromise that the House position represents. With respect to jury trials, I think in practice, all that's going to happen is that folks are going to be holding on to property that's been seized longer. And some of the testimony is that, in fact, law enforcement may have to get additional storage facilities because they're going to be storing this property for so long while folks are waiting for jury trial. I've been here 4 years now. My first 3 years here, every single session, we had to suspend the right of speedy trial because we had such a backlog when it comes to jury trials. We're just making our way out of that. And now we're going to grant the right to a jury trial to this whole other class of people. We simply can't process these cases in a timely fashion. So the result is just going to be that folks in Kansas are going to have their property held longer, and they're not going to get a timely jury trial. And with respect to federal adoption, I think that would really cripple the use of civil asset forfeiture. We've got, as Representative Lewis mentioned, we've got a major fentanyl crisis in the state. We have challenges with other criminal activity in the state. I don't think this is the time to go wobbly and to go soft on crime. I just fundamentally think that giving up the right to allow local law enforcement officials to have federal adoption is, to me, fundamentally a soft on crime position, and that's not a position that I'm willing to take. If you think about our law enforcement resources in these small counties, they could be a dozen people, maybe, probably less than that in a lot of instances. And so if they have a significant investigation in their county, if they can't ask the federal government to provide them extra resources, one of two things is going to happen. Either they're not going to be fighting all the other crime because all their law enforcement resources are going to be tied down on this investigation, or they're simply not going to be able to do a competent job with the investigation. So, reluctantly, Madam Chair, I'm strongly with the House for all of those reasons. We have a negotiated compromise. Jury trial is just going to keep property of Kansans held longer, and federal adoption would basically kill civil asset forfeiture as an important law enforcement tool at a time when we have a fentanyl crisis and other issues of criminal activity in our state. And again, I'm just not thinking that I want to go wobbly on crime at this point. So thank you.
Before we have Senator Wilborn make comments, want to reiterate that there's nothing wobbly on crime about either of the positions taken here. There is nothing that, if the Senate position were to pass, that would prohibit civil asset seizure and forfeiture from continuing. It just puts guardrails in. So let's be clear about that.
Thank you, Madam Chair. Just a couple of comments. I chaired the Judiciary Committee several years ago, and this issue surfaced, of course. There was a post-audit report that was pretty damning about some of the abuses that was going on in several communities. It wasn't statewide, but it was pretty severe, and not in frequency, but in severity. We took action to correct some of that by the reporting requirements. There was a move then to abolish civil asset forfeiture. I was able to hold it off because I think it's a valuable tool. Secondly, the interim committee that was formed is a committee. That's all it is. It's not a bill writing committee. My chairman was not invited to the compromise report. She was not part of it. She had no input on it. And to say it's a compromise, I think our Senate position is a compromise. That's where we draw it. So that's where I stand on that. And I thank you, Madam Chairman.
Thank you. So we're kind of at, we've got the Senate position is a strong position, and I understand your position in your chamber is what it is, strong as well. So we've got the three pieces that are different, and I want to also state, since it was brought up, that law enforcement prefers the House version, is that when federal adoption occurs, there's no requirement any longer that the federal adoption comply with any of the guardrails that the state of Kansas has put into place. And so it would simply be government entities circumventing the will of the legislature and the will of this body that we put into place some guardrails. And we need to make sure that the legislature, when we say something, we mean it and it is followed. So it would be federal adoption is a way to bypass the state reforms that we would put into place. And as far as jury trials, we've addressed that as well. If you don't want to wait for your property to be returned, guess what? You're not going to request a jury trial. It's completely within the hands of the person who has had their assets seized, and they can make that determination. We also heard reports every year that I've been chair of the committee for the last 4 years. We heard updates from the judicial branch that we, at this point, do have our criminal jury trials back on target. And remember, the trials here that we are talking about are civil trials. They're not criminal trials. They're civil, and again, only at the request of the person who's had their assets seized. So the Senate stands firm in its position on the 3 pieces. Would be willing to entertain some further discussion on them if there is any.
I do think maybe more discussion is going to be what we need to have, because I think there are some misunderstandings, possibly misinformation, and and you talked about studies and evidence and different things, and I would like, I've heard people say that the federal adoption is maybe a loophole to get around some of the state reforms, but I haven't had anyone testify about that. I haven't had any information about that. I'd like to know more about what they're talking about, because some of our reforms that we're putting into this bill would happen before the feds were actually asked to adopt. And so our reforms would still be put in place. So that's one thing I'd like a little more information on. And then the other thing is, yes, we've all heard that it costs $5,000 to hire an attorney to get $2,000 back, and that whole piece is egregious, and we don't like that. And that's why there was the fee shifting. That's why there was the point where those legal fees would be paid for by the other side. And so that gives relief to the people. And of course, we're all in favor of, we know we're balancing freedom and safety. That's what we're balancing all the time in the legislature. And, what is the right middle ground? And, I just will say again, the House feels like our position is the middle ground, and we've come a long way, because we're not just talking about these 3 things. There are other reforms that we have all agreed to, increasing the burden of proof, taking out some of the drug offenses, all of those things. We are making progress with civil asset forfeiture, and we need to continue to make progress. And the last thing I'll say has to do with the jury trial. There are some people who have said, well, that's a constitutional right anyway. And so if that is true, then let's go along with the House position and see what happens. Maybe the courts are going to say that someone in that case, someone in that situation could ask for a jury trial. That very well might happen. Let's see how that plays out. But I think by us saying that they don't have the ability to request a jury trial, let's see how that plays out, because that very well might be a constitutional right that I'm happy to see if that's how it plays out in the court. So with all of that, and again, if either one wants to comment, please go ahead. I do think we need further discussion and maybe a little more data gathering with a few things.
Thank you. That evidence is already in the record, Madam Chair. It was presented in the Senate committee, the studies and the reports. So that's all publicly available already as it is. And so I think we need to look at also remembering there are 2 chambers. And so the Senate has a position and the House has a position, and neither is really a middle ground because they're different. So they're different, and we're here to see if we can reach a report that would provide some middle ground. So with that, I think Representative Lewis, and then Senator Wilborn has a comment.
Thank you, Madam Chair. So I just wanted to comment about the interim committee on which I sat. I believe Representative Osmond was on the committee, Representative Wilburn was on the committee, Chairwoman Warren was on the committee. I believe there may be some others in the room that were on the committee. What I saw happen is we heard what we heard, the full day of hearings, and then we talked among ourselves and we voted on different provisions that we agreed upon or didn't agree upon. And my understanding is that's what was reflected in the report. And what was reflected in the interim committee report is almost to the letter what we then in the House agreed upon in our Judiciary Committee and on the floor. And that was definitely a compromise. A lot of what we heard that day was the different stakeholders coming before us and saying, we've already talked about a lot of this stuff, and this is what we don't want but can agree upon, and what we've agreed upon, and what the committee basically did was adopt that. One thing that I don't think they quite agreed upon, but we passed out of the committee was a motion by Representative Osmond to increase the burden of proof from preponderance of the evidence to clear and convincing evidence. I will tell you that I opposed that motion, but I lost. But I certainly support the compromise that we reached. So I'm just saying that, there were people in that room that day that on the law enforcement side that weren't particularly happy with what came out of the committee, but we agreed to proceed with the compromise that we reached.
Thank you, Madam Chairs. So, Senator Warren, you are correct that the Judicial Council, there's the report that came out of the Judicial Council is not binding upon the legislature whatsoever. And you're correct that the Joint Committee, that is not binding upon the legislature whatsoever. But I will say that the reason that we're here is because of those things. 3 years ago, I tried to introduce a bill on civil asset forfeiture, and it didn't make it out of committee. Neither did multiple other bills that year. Last year, we had 3 bills in the House on civil asset forfeiture. None of them made it out of committee. So even though they are non-binding, the only reason that we're sitting here at this table today is because of the hard work and the compromises that took place in those hundreds of hours through committees beforehand. Because until we got through the Judicial Council, we had no position whatsoever that we could even sit at the table for. We had nothing that could get out of any committee whatsoever. So that's the reason that we are so strongly as the House committed to what actually came out of the KJC is because of that is a compromise that we actually managed to work out with all the different parties. And again, as I said, with the Joint Committee, you're right. It was not binding. There was no obligation that anyone speak at any given time at the committee. But as Representative Lewis said, 4 of the people here at this table were at that committee and had a seat at the table to have those discussions. And we, so in terms of where we're at today, it came out of those discussions, both through both different both committees. So where we're at today, I feel strongly that the House position is where we need to be. Thank you very much.
Thank you. So during any of our discussion, I'm sure we haven't had any advancement on the balloon amendments for 2144 or anything else. So, or for Senate Bill 500, but we do need to get to those bills as well, and need to give our revisers time to put those together because the hour is drawing near when, first of all, we have to get back on the floor. We're back on at 5:30. Are you as well? You're back on at 5. Okay, at 5. And then we also have, and we'll come back to the discussion on 458. If I could ask you a few questions about Senate Bill 473, one of the things that the House did was put in House Bill 2755 into it, but not as amended by the Senate. So could we have the reviser kind of update us on 2755 as it is now in Senate Bill 473? Because the Senate worked on 2755 as well.
Sure. Thank you, Madam Chair. I can kind of talk about what the House did, and then Jason can compare that to what the Senate did. So 2755, as originally introduced, had two components. Actually, the first section dealt with municipal court bonding, and the second one was district court bonding. And so, what the House Judiciary Committee did is take only Section 2 from House Bill 2755, and they inserted those contents into Senate Bill 473. And so that was the House action.
The original contents of 2755 minus municipal court part.
After the House committee amendments. So 2755 was worked by the House committee and sent to the House floor. And the House committee did make a couple of minor amendments. That is the version that's represented in Senate Bill 473.
Okay, so
but not the Senate amendments.
Okay, but yes, we need to know where the Senate amendments are.
Madam Chair, so I believe I'm looking at it again just to make sure that Section 2 of 2755, as amended by the Senate, matches the version that was put into this package. I don't believe the Senate amended Section 2. The Senate did amend Section 1, which is not in this package. And the amendment in that Senate version of 2755 removed the requirement that the amount be the same regardless of the method used to secure the appearance of the accused person. So it kept in the provisions about authorizing appearance bonds, but not the provision saying it had to be the same regardless of method.
Okay, thank you. Are there any questions regarding Senate Bill 473? Not seeing any. Then I think we need to wait on some of those balloon amendments for Senate Bill 500 and 2144 before we advance too far down any other road. So with that, I think we're going to conclude our work right now.
I am curious if the Senate had another position on House Sub for Senate Bill 349, which is one of the other ones that are in the committee. It's that annual open records exemptions that we do. I didn't know if there was anything else that you all wanted to say about that, or if you had any thoughts about that.
Not yet, not at this time.
Okay, thank you.
Yes. So with that, then, to let you all get back on the floor in time and to let our revisers work on some balloon amendments, if they would, then we will go ahead and before we adjourn, make sure that if there's going to be announcements on the floor that we have that ready as well. And do we have one from Senator Wilborn? Okay, with that then, go ahead.
Just wondered if we wanted to go ahead and set the next time for meeting, or if you want to wait. And I know, Madam Chair, that you do have several other conference committees still, so you're probably, your schedule is a little bit more packed than ours is. So, you know, if you know when you might have free, we could maybe make that work, but
We are conferencing with House Veterans and Military Affairs at 9 tomorrow morning. I think we announced that earlier on the floor today. If we get some of those balloon amendments back while we're on the floor, maybe we could. I'm not sure, but I do need to also then schedule a conference with House Corrections as well. So stand by if you could,
We will,
maybe on
at your
first recess of the second chamber tomorrow, since we have the 9 o'clock, and then that would be,
okay, if we could tentatively say that, that sounds great.
yeah, the first
Okay.
recess of the second chamber.
Mhm.
Okay,
Perfect.
great. And with that, then we are adjourned.